Hello, I'm Dalton Delan. I'm a columnist for the Berkshire Eagle, and this is Eagle Reels, where we take you beyond the news. Our guest today, H. Jefferson Powell, professor at Duke University's School of Law. Welcome, Professor Powell.
Thank you. Good to be here.
Thank you. Going back, first of all, to some history. During World War I, President Woodrow Wilson sought broad emergency powers, but Congress gave him more restricted powers related to particular statutes. These small emergencies have seemed to persist like a common cold, waxing and waning, but never going away since. Is that correct?
That is correct. From early on.
You served several times in the Department of Justice. Based on your experience there and elsewise, is it a fundamental flaw in U.S. law that constitutional and emergency government are permeable?
I think it's unavoidable. Unavoidable because the system is meant to produce, as in one of the greatest separation of powers opinions, Justice Jackson's in the Steele seizure case, says it's intended to create a workable government. And that necessarily means a government that can sustain society and maintain itself. On the other hand, since a fundamental principle is that government can only act in our system insofar as it is authorized to do so constitutionally, well, you get the tension. The interplay between the executive's, I think we can say in general, legitimate concern to make sure that emergencies are met, and the fundamental principle that you can only act executive if the Constitution authorizes you to do so, either directly or through Congress. That tension can't be resolved in any final way.
Mm-hmm. Well, by the fall of 2005, taking us back a little bit, 41 states were in separate presidentially declared states of emergency due to precedented crises such as Hurricane Katrina. The internal logic of those emergencies seemed to satisfy a generally recognized justification. You've appeared before the Supreme Court. Is the court accustomed to deciding on the validity of emergencies?
That's a great question. And the answer is no, it ordinarily defers. And it defers for reasons that make sense. The justices don't know anything of their own ability about the situation. They're not competent to make the decisions that are policy decisions, and they take that into account. And that's been a consistent feature since the Supreme Court first encountered these kinds of questions. On the other hand, it goes all the way back to the quasi-war with France in 1798 to 1800, that the Supreme Court has insisted that where Congress has the power to grant the authority, it may also limit the authority, and the executive is bound to respect whatever limitations it gives. And then again, much more recently, although to be sure, almost 100 years ago, in Sterling against Constantine, which was a 1932 decision, unanimous, 9 justices, Chief Justice Hughes, a great Chief Justice writing, the court said it's beyond dispute that the courts do not have to simply accept an executive officer's declaration that something is an emergency. So although there's great deference, deference is not the same as we have to swallow whatever, as Hughes said, the executive says by fiat. And Sterling, by the way, was about a governor using gubernatorial powers, but the Chief Justice Hughes's opinion made it clear that the same reasoning applies to the president.
Well, to follow up on that, okay, so David Posen, you may know him of Columbia Law School, he has said, quote, if you invoke an emergency in area after area after area, you can grope your way towards something resembling a general emergency power, unquote. Now, towards solutions, the Brennan Center for Justice has called for a sunset provision, right, on emergency powers after 30 days, and Congress would need to reauthorize that power. But certainly this Congress seems far from asserting its power.
Well, that's right. And that points to a flaw in the, and this may really be a flaw as opposed to an unavoidable aspect of the system. Uh, we are assuming that Congress will exercise its powers. And indeed, in the wake of Watergate and President Nixon's resignation, Congress passed an act that was meant to reform the vast number of situations where Congress had authorized the president to declare an emergency and change the legal rules on the ground. The act has clearly failed. It's failed to do so. We now have a plethora of statutes that allow the president to declare emergencies, and the president does so as presidents do. Uh, and, there's a wonderful opinion worth looking at by those interested in these questions. It's Justice Souter writing separately in the 2004 opinion case of Hamdi against Rumsfeld, in which Souter points out that the executive branch, which is responsible for dealing with emergencies, is not the best branch to entrust with the decision about when there's an emergency, even though you may have to do so sometimes, because it's going to, on the best possible grounds, executive officers acting in the best, most greatest good faith, they're going to see emergencies where you and I do not. So that's a problem. And in one sense, it can only be ultimately fixed by Congress. I would love to see the Brennan Center's proposal on this, as on some other matters, adopted by Congress. You and I don't expect that, not anytime soon. But that doesn't mean that the system has no sort of fallback. And that is to keep in mind that, notwithstanding Dave Posen's correct observation, add up A plus B plus C and you end up pretty soon with Z. Notwithstanding that, in any given situation, unless the executive has the power to draw on Article 2 direct constitutional power, and by the way, there's something between none of that and very little of it in domestic affairs. So if the president is drawing where ordinarily he or she must on congressional authorization, it is open to the courts to entertain the question, has the executive officer got the proper basis for invoking the emergency? That includes the president, and that, notwithstanding deference, means that the courts have the ultimate responsibility of themselves deciding, with all due deference, do you have a basis for invoking this authority?
You're making a great point. I mean, I think that with the polarized court and a 6-3 court that we have now, I think a lot of people would say this is a court deferential to the president. But you make the point that is just as is the executive the right person to actually determine the true facts need for an emergency, that the court itself is to decide on matters of law, but isn't in that sense a fact-finding committee. So what do you feel about this general perception and the question of whether a court, which does seem favorable, if that's fair, a little bit more now to executive power than prior courts, is or isn't potentially deferential in this matter of emergency powers? Your perspective?
Okay, yeah. Now, it's a general observation. There can be no argument that the current majority on the court favors a broader view of executive power in at least some matters than have some previous courts. For example, the court's going to hear argument very soon in a case in which it's being asked to overrule Humphrey's executor, which is a 1930s decision, which recognized Congress's power to limit the president's power to remove certain high-ranking executive officers, except for cause. And if the court were to overrule Humphreys, that would mean that I think, misnamed concept of the independent agency is gone. Because when we talk about an independent agency, what we clearly mean is an executive agency, the head or heads of which is protected against at-will removal by the president. So whether or not the court takes that final step, it's gone a long way towards restricting Congress's power to limit the president's removal authority. So that almost by definition says it's a court, a majority of whom think that the president's power is broader than some earlier majorities have thought. Now, let's just start with that as an observation and then make a second point. I'm not unless you ask me. I'm not going to opine on because it's not really relevant to this discussion whether I agree with the current court or not. But what I think that we all need to keep in mind, and the we here includes the 9 justices, is something that Chief Justice Roberts said during his confirmation hearings and has sometimes repeated since he's been the Chief Justice, and that I think is a vital point in our system. The courts sit only to decide particular cases and controversies, which means, from the standpoint of the political branches, to their relief, it doesn't have some general supervisory power to tell the executive or Congress, for that matter, how to manage their own concerns. On the other hand, the flip side of that is that the court has an obligation, a duty to decide court cases in its jurisdiction one by one. So let's imagine a member of the current court, and let's call him, just for the sake of argument, Roberts. And let's say that he has a generally strong, robust view of executive power, maybe more robust and stronger than Chief Justice Hughes did almost 100 years ago. On the other hand, as this justice should remember Chief Justice Roberts saying in his confirmation hearings, our job is to decide cases, particular cases. And that means that the problem Professor Posen has correctly pointed out, which is the accumulation of individual powers, can be and ought to be disaggregated by the courts, not out of hostility to the current president or any president, but rather because that's their job. You've got a particular case before you, and although you should engage, you should pay careful attention to the extent to which you should be deferential to the president. It's your job in the end to decide, almost always, what the law is. And it's the executive's job to do what the law requires.
That's very important. Let me probe a moment. Another, let's call it a pushing of the boundary of emergency powers. Under President George W. Bush, after 9/11, he interpreted, or those around him did for him, Article 2 of the Emergency Powers Act to give him broad powers without a public declaration. I think that enhanced interrogation, quote unquote, is an example of this. Perhaps one could term this a sort of stealth use of emergency powers. Is such a thing legal or illegal? Do emergency powers, if invoked, need to be public?
The basic answer is yes. And the legal questions that come out of President Bush's response, the Bush administration's response to 9/11, are complicated, and then they don't always have the same answer. Given the fact that Congress authorized the executive to take all appropriate measures against the perpetrators of 9/11 and those supporting them, as the lead opinion in the Hamdi case I mentioned earlier says, this authorized the executive to do anything that's within the laws of war when directed against the perpetrators of 9/11. And that's very broad, not unlimited, but it's very broad. And it extends primarily to actions pointed outwards, but not solely to that, because there are things that congressional authorization of hostilities would permit the executive to do that are internal. So, for example, the Hamdi case itself was about whether the executive could detain an American citizen in the United States without charging him with any crime at any point, and just keep him indefinitely detained. And the lead opinion, and indeed the court as an institution, said, no, although you're authorized to detain, you're not authorized to detain indefinitely when this person claims that I'm not an enemy combatant. You've got to either release or provide some kind of due process. So that's a good example of looking at a particular issue, deciding it in one sense quite narrowly. The only decision was that someone in Mr. Hamdi's position has to be given some kind of due process procedure. And that didn't necessarily mean, the court said, that it had to be in a judicial federal court form. It could be within the executive branch, so long as it obeys fundamental due process concerns. So it's quite a narrow decision. On the other hand, it's a decision that upholds the rule of law by both interpreting the authority the president has and saying that in the end, we decide what authority you've been given. All due deference, we decide that final question. And furthermore, the lead opinion, and indeed the two separate opinions that came out to the same basic conclusion, uphold a fundamental constitutional principle, which is, once again, you don't have to think poorly of any given president. That's something that you and I might disagree about. But the point is that presidents and executive branches, by their nature, are going to push the envelope, even if they're the best possible executive imaginable, because that's their job to protect the country. The court's job, case by case, is to make sure the law is followed.
You you are a great, you'd be a great producer because you led me perfectly to the segue I want to make. So talking about these precedents and what you were just saying. So some what historians might term the quote unquote great presidents. Okay, let's talk Abe Lincoln, FDR. Okay, they clearly played fast and loose with constitutional rules. Go fast forward to President Barack Obama. His chief of staff during the 2008 financial crisis said, quote, "You never want a serious crisis to go to waste," unquote. So moving in a moment to President Trump, he's not appearing out of thin air, is he?
No, not at all. Uh, and this is not to agree or disagree with the proposition that he's pushing the envelope harder than many earlier presidents have, but absolutely not. On the other hand, let's think about FDR. Uh, FDR certainly pushed hard on the envelope on matters like the president is bound by rules Congress lays down that are within the scope of Congress's power. So that, for example, at one point, Congress had forbidden the deployment of U.S. military forces outside the Western Hemisphere. President Roosevelt found a geographer who said that Iceland, to which the president deployed troops, Iceland's in the Western Hemisphere. This is not a majority view. In fact, this is a very unusual view. On the other hand, there's something crucial about that. And I'm not, if I had been FDR's advisor, I would have gotten myself in hot water by saying, I don't think you can do that, Mr. President, even if you say that, and there's some PhD somewhere who will agree with you. Nonetheless, notice then in his cheating, Roosevelt formally obeyed the law. And that itself is a crucial matter. This, let me remind you of the Korematsu case, the infamous and properly infamous case upholding the detention and concentration camps of American citizens because of their ancestry. Okay, so in Korematsu, one of the dissenters was Justice Robert Jackson, the author of one of the greatest opinions. I've already alluded to it in the Still Seizure case that's about these issues. And Justice Jackson pointed out that if the executive, and Jackson thought the executive was, violates the Constitution by this racist, race-based confinement of American citizens, taking them away from their homes and putting them in concentration camps. If the executive does this, which is blatantly unconstitutional, and the court doesn't approve it, then it's just the executive disobeying the law. It doesn't create a precedent legally. The crucial matter for the system is that the system not accept that the system be able to treat that as an exception, showing that even famous and great presidents can do things that are wrong, at least legally wrong. That's all it shows. And Jackson was writing in a context where a majority of the court, 6 justices, were upholding what President Roosevelt did, which then created, as Jackson pointed out, a president that lies around like a loaded gun, waiting to be used by some future president who may not be as conscientious as the one who's acting.
Well, okay, now, all right, you've moved us into the theater of Chekhov there, right? With if the loaded gun is present, right? Is it going to get used? Let's go to the moment that I think concerns people and probably why we're sitting here today, right? Trump has declared at least 10, to some degree, unprecedented emergencies. And here are a couple of Trump quotes. Quote, Harvard is a threat to democracy, unquote. A legal ruling against his tariff plan would, quote, literally destroy the United States, unquote. We know that he's a bombastic sort who, speaks on the cuff, but on a deeper basis, can anything a president deem an emergency be an emergency as an extension from everything we've been talking about?
Absolutely not. That's the teaching of Supreme Court decisions from the ones I mentioned that came out of the quasi-war with France back at the very beginning. It's consistent. Chief Justice Hughes, in that case I mentioned, Sterling from 1932, said this issue is settled. No, the courts are not bound, no matter how deferential they should be, they're not bound by the president's determination that the facts accord with what the statute requires. And of course, they're not bound by the executive's reading of the statute. And let me just say one other thing in this connection, because I love your juxtaposition of two different kinds of situations. I don't even fully understand Harvard as a threat to, well, matters. But let's talk about, we could bring up the president's deployment of National Guard troops or attempted deployment to address law and order problems. That's a matter where if the president has a statutory authority, which means if the facts support what the statute requires, then the president, I think, has quite broad leeway to make use, in his best judgment, of the National Guard once federalized. But notice we've got those two crucial matters. The facts must support a decision that the statute is available, and the statute must be conformed to. So that, for example, if the president is required to issue a proclamation ordering the supposed insurgents to disperse as part of the deployment of the National Guard, and the president fails to do that in a proper fashion, proper is decided by the courts. Then the president has not acted lawfully, and the court should say so. But I want to distinguish that incredibly important situation from the other, the tariff matter. Let's imagine a situation where the courts conclude that Congress has not authorized the president to do the things with regards to tariffs that the president wants to do. Is there an argument that the president can do so nonetheless under a national security rationale, national defense, whatever? And the answer is, I submit to you, and there are lots of things that are debatable, and you will find people who will disagree with what I'm about to say, but I think they're patently wrong. If you're talking about Congress's power over money, this was understood by the founders to be, this has been consistently, this is the ultimate check on the executive. The fact that the executive may not spend a single penny that Congress had not authorized. And Congress authorizes all kinds of things that it's probably in providence to do so. But if the president goes against what Congress says on a money matter, there we have not just a loaded gun with respect to a major matter. We have a loaded gun pointed at the ultimate check on executive power. And why am I talking about that as if I'm afraid of executive power? That's because I am. I'm also afraid of judicial power. I'm an officer of the court. And I'm afraid of Congress's power. Yes, all three branches are dangerous, not just one of them. But the executive has the ability to do something that the courts can't do at all, and Congress cannot do in effect, which is to actually harm individual human beings. Because as executive, that's the part of our government that takes action. So we need to bear in mind, and the courts need to bear in mind, the relative importance of the issue before them, which is not to say they should say, well, it's not important. Anything that's a legal issue is important legally. But it's to say that your examples are good because they bring up different concerns, both of them very important. Does that make sense?
Yes, indeed. I mean, but it does make me think, well, I hope this Congress wakes up and remembers that the power of the purse is its.
No, they need to.
It's not been evident recently. Um, okay,
And
I'm
the particular Congress right now is
right.
not the one that began. As I said, the problem of emergency powers and overly broad discretion is one that goes back many, many decades.
Okay, so going back, I'll take us from look, we're almost at the 250th anniversary of the country. I'm going to go back to the beginning and then take us up to the sort of dark precipice that has some people quite concerned. Okay, so Thomas Jefferson, quote, "There are extreme cases where the laws become inadequate, even to their own preservation, and where the universal recourse is a dictator or martial law," unquote. Now, looking at examples of, shall we say, the decline and fall of democracy internationally, and the playbook that some are concerned that this president may be following, advertently or inadvertently, right? Ferdinand Marcos in the Philippines, communist insurgency, right? President Erdogan of Turkey, a failed military coup. Viktor Orban of Hungary, justifying suppression of civil rights by COVID, Ukraine, immigration emergencies. So, in this dark scenario, are is this a potential road via martial law? Is this a potential road to something other than the balance of powers democracy that we I think all think we have in America and want to have into the future?
2 points. Let me start with Thomas Jefferson. He's a great person to invoke because Thomas Jefferson, this is in a different letter than the one you're quoting. Um, Jefferson said in explaining why he allowed the Louisiana Purchase to be consummated by his administration and Congress, even though he personally thought it was unconstitutional for reasons that most other people didn't agree with, but still, that was Jefferson's view. And he said, well, sometimes it's the obedience to the law is a high duty, but it's not the highest duty. Um, Sometimes you just need to do what's right for the country and then throw yourself on the electorate and say to them, I've done this. Now, he didn't do that with respect to the Louisiana Purchase. He just went ahead and followed the advice of his advisors, who I think correctly said, no, we can do this. This is not unconstitutional. But he thought he was breaking the Constitution, and he thought that was okay. Jefferson also thought, with respect to the Sedition Act of 1798, which he fiercely attacked is unconstitutional, he says that the courts, of course, were entitled to follow their judgment. I, as president, pardoned everyone convicted of the Sedition Act violation. The courts convicted them, and they were entitled to do that because that was within their sphere. So Jefferson, who's often invoked as a very early believer in the existence of extra legal presidential power, recognized that, well, I can do X, but the courts then must follow their view and do, if they think it right, not X. And that means that the president could think I'm properly going, saving the country or whatever, and the courts should still say, well, but that wasn't lawful, Mr. President. And on Jefferson's own view, the courts are entitled to prevail on the case by case basis. That is the way our system works.
Were things,
Go
Professor
ahead.
Powell, were things different in literally in timing then because of the issue today that the judicial recourse can have a lag time, even though it is, that potential corrective. But we've seen now in recent years whole, departments, be eliminated and so forth. Under the sort of damage can be done by an executive before judicial recourse catches up with it. Was that different then, or is it as a part of something Jefferson, for example, understood, and it's just the way we're constructed?
Well, it's mostly the last thing you just said.
Hmm.
Uh, the executive, there was very little in the way of an executive branch in Jefferson's day. There were something close to no federal agencies as we would understand them. So the major thing that the executive branch did was act through, well, U.S. attorneys prosecuting people for doing things. And then, of course, that gets you immediately into court. So the ability of things to take place within the administrative state that then take quite a while to percolate through to the legislature, excuse me, to the courts. That has changed. That said, what is our alternative? What other system do we have that's compatible? Now, maybe there are other alternatives in the abstract, but as a lawyer, I tend to try to think not in the abstract, but in the terms of the system we have. And I don't know that there's another way to have it that has the advantage of an ultimate recourse to the judiciary without having the judiciary in there up front, sort of getting involved in running things themselves when they're not competent to do that. But then the second point I want to say in response to your great question is that, am I worried about these dark scenarios? If the US Supreme Court were to say, well, this seems unconstitutional to us, but the president's decided it, and therefore we defer. And I've just made up something that would never actually be said in those stark terms. If the court ever were to do that about this or any other president, then I think we've got a serious constitutional crisis. But not only has the court not said that, and the immunity decision doesn't say that. It's a complex matter, but it doesn't say that. The court went out of its way in the universal injunctions case from just a few months ago to point out in a footnote that on being asked, the Solicitor General assured the court that, of course, the executive will obey orders of this court, so long as the executive does not break that fundamental rule, and so long as the court lives up to its side of that, then no, the system has not malfunctioned. We may be seeing problems that the system is not addressing in a retail manner, and that would be regrettable, can be very regrettable. But we're not seeing the kind of problem that Abraham Lincoln did confront, because Abraham Lincoln confronted a situation that within a little over a month of him taking office, there were 11 states of the Union in which, with the exception of a couple of federal forts, there was no U.S. government authority at all. That's not this situation.
Yeah,
and so Lincoln, I
that's
think it's
spot
not a
on.
good precedent
Right.
for anything.
Right. We hope we don't face that true constitutional crisis.
Yeah.
Are there elements? I mentioned the Brennan Center idea earlier. This is my penultimate question, beginning our dismount here. Are there fixes you would suggest or could foresee that will somehow help us?
Yes. Number one, following the Brennan Center's lead, and its particular suggestion is a fabulous one, Congress needs to revisit the whole question of emergency powers and the authorization for the use of military force that was Congress enacted after 9/11, and that I think ridiculously the executive is still relying on. It needs to address any future grants of emergency or military use power. So there are a lot of things that Congress should do. You and I don't think that's going to happen tomorrow. But the fact it's not going to happen tomorrow doesn't mean it won't ever happen. Things look pretty grim in, say, 1896, when Plessy against Ferguson was decided to imagine the segregation decision, upholding it, to imagine that Congress would ever do anything serious about civil rights. But ultimately speaking, to be sure, decades later, Congress did. So I'm not willing to give up on making the points about what Congress should do. And of course, you and I as voters, the president himself, the current one, and any other future president, as an office holder, and all of the president's subordinates need to bear in mind the duty of the executive to obey the law. That's the second remedy. The third remedy is the one I keep referring to. The courts need to take seriously not the idea that they're supposed to be there swatting down this administration or any other, but that they're supposed to be deciding in their best judgment decisions involving life, liberty, and property. And they can't or should not finesse that or abandon it or try to avoid awkwardness. They needed to step up to the plate. That's their job. If they're not willing to do that job, they ought to take another job.
Well, finally, then you've noted that it is not your expectation that even this administration, based on its statements, would force confrontation with a ruling of the Supreme Court. Okay, so is anything else that keeps you up at night? And on the better front, and we've also talked about, a Congress unlikely to enact some of the fixes we'd like to see. But what does give you hope, given the reality of what you see in front of you?
Two things. One is, it is, as I see it, I think, a view shared by the vast majority of Americans, regardless of who they voted for, that our system, and Americans oftentimes talk in terms of democracy. I might say that's fine, but use the word very broadly. I don't mean just democratic elections, even just free elections. I do mean the system of free elections, electoral responsibility, which follows from that, but also the rule of law. And I think that's a shared value. I think our debates, and debates isn't even the right word. Sometimes we just are shouting at each other. And that's regrettable. And I see one of my own jobs, tiny little role, is to try to mostly help my students understand that their job as lawyers in the future is going to be help us reduce the shouting and make more of a debate, understanding that we're not all going to agree ever on many matters. But I think we share, the vast majority of us, this commitment. As long as we do, I'm not in the end deeply worried. The thing that bothers me the most, and this is really parochial and narcissistic, and it's just, I'm a lawyer and a law teacher. What really sometimes bothers me personally as much as anything is when you have people, and Professor Posen is not one of them, I'm happy to say, when you have people who are law teachers or prominent lawyers who seem to have lost faith in the law.
Hmm.
Because when you see that, if the lawyers lose faith in the law, why is anybody else going to keep their trust in it? And our system depends on the rule of law. A famous English historian, E.P. Thompson, who was a Marxist and didn't much like lawyers or courts or anything of the sort, they were tools of the powerful and rich. Thompson once wrote that the rule of law seems to be an unqualified human good. I think that's totally right. I think this country is committed to it. I think our system has it, is imperfect and often flawed as it is, and we need to protect that. And when people lose their faith in it, then I'm lying awake at night, and I'm not even joking, literally worried about things.
Professor Powell, you have, not unlike your students, I think you've elucidated a lot of very complex issues for our audience today, our readers and our viewers. And I thank you very much for bringing that wisdom and that light and a bit of that justified, I hope, hopefulness to us today.
Thank you so much.
I'm Dalton Delan, and this has been another episode of Eagle Reels. For those of you who are already subscribers to the Berkshire Eagle, thank you so much. If you're not yet a subscriber, please consider becoming one. It's how we maintain all our work, the flame of local journalism, conversations such as this. I'll see you next time on Eagle Reels and in the pages of the Berkshire Eagle.